One of the things I love about being an attorney is that I get to see so many ways that companies screw up. It's like watching train wrecks in motion. My law firm has shelves and shelves of legal books containing law cases where companies make mistakes and have to go to the courthouse to get the mistakes resolved. We're going to talk about 5 mistakes that companies make with respect to patents. Some of these mistakes can cost millions of dollars. Hi, my name is Carr Ferrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. Okay, one of the most serious ways that you can get in trouble with your patents is to file your patent application too late. In the United States, you have a 1-year grace period from the time of first public disclosure to getting your patent application on file. Now that's just for the US. If you want to file patents in foreign countries, you generally have to have your patent application on file prior to the disclosure or the public disclosure of your invention. We call this absolute novelty in foreign jurisdictions. Now, this problem of filing your patent application too late actually comes up a lot. It's come up in my litigation practice, where I've been able to invalidate patents because I've found evidence of prior publication more than 1 year before the filing of the patent application in the lawsuit. And it can be really devastating when this happens. It's game over. If there's evidence of a prior publication more than 1 year before the filing of the application, the patent is invalid. And we may not find this prior publication, this invalidity, until years after the patent issues, when the patent's being challenged in court. So it's important to get your patent application on file early. Now, there's one famous case called Clock Springer versus Rapmaster. Clock Springer filed a patent application in 1992 for a method of repairing a pipe once it's in the ground. The pipe rusts and there's gouges and defects in the pipe. So the pipe gets dug up, the rust material gets scraped away, and a goop gets filled in to fill in the dents and the gouges on the pipe. The invention was that once the uncured goop or filler material was put into the divots and the gouges in the pipe, then a wrapping material like a Band-Aid was wrapped around the outside of the pipe until the goop material actually cured and hardened. Now, it sounds like a pretty important and valuable invention, except that in 1989, 3 years before the filing of the patent application, one of the inventors was demonstrating and describing the invention to some potential customers. Evidence of this prior public disclosure was admitted into the case, and the patent was eventually invalidated. The lesson here is that it's very important to get your patent application on file prior to public disclosures, prior to offers for sale, prior to going to conferences and writing papers about your invention. Okay, a second mistake that companies make with respect to their patents is filing their patent application too early, filing it before they really have their invention completed. Now, it's not necessary when you file a patent application to have built a prototype or to completely have it built the product that you're trying to patent. But you do need to understand the details of how your invention would be built, how it would work. The example that I like to use is the perpetual motion machine. Now, it might be that you have a concept for a perpetual motion machine and you realize that a perpetual motion machine would be a great invention, but you're missing a couple pieces. For example, you don't know how to build the frictionless bearing that's required to make your perpetual motion machine work. Well, until you get the pieces, until you understand all the various parts for implementing your invention, or could get to the understanding of those parts with a small amount of experimentation, then you really don't have enough yet to file your patent application. An important law case that discusses this point is New Railhead Manufacturing versus Vermeer. In this case, New Railhead had a patent on a technique for horizontal oil drilling. Now, typically when you drill for oil, you have a drill that goes straight down, vertical drilling. But there's some cases in which horizontal drilling becomes valuable. For example, let's say you're drilling next to a lake, or you're drilling next to a building, or you want to get to oil that might not be on your property, that's on your neighbor's property. So you drill down and the drill bit can actually turn and you can drill horizontally. Well, New Railhead had come up with some technology that enabled this. They filed a provisional patent application. They then followed on with a non-provisional application and then ultimately sued a couple of companies for stealing their technology. Now, I'm not exactly sure what happened here, whether the technology was patented before it was actually ready, or whether it was just amateur hour with the provisional patent application. But the provisional patent application did not describe in detail how to actually get the drill bit to drill sideways. There just wasn't enough detail in the application. Now, the inventor on the witness stand said that he understood in his head how to do it, but he just didn't get that information down into the provisional patent application. In its opinion of the case, the court seems skeptical as to whether the inventor really understood the invention at the time that the provisional patent application was filed. But in any event, the patent was held to be invalid for failing to describe sufficiently the details of the invention. Now, the third mistake I want to talk about really is an extension of the second mistake. That is, filing your patent application too early. We saw in the last example, the provisional patent application just didn't have enough detail in it. And presumably, we assumed that the inventor just didn't have the detail. The invention was not ready for filing. However, the third mistake occurs when there's just not enough attention paid to the preparation and filing of the provisional patent application. That is, it just doesn't contain enough detail to fully explain and support the invention. One of the famous cases that discusses this issue is Dynamic Drinkware versus National Graphics. Now, this is a case where Dynamic Drinkware had come up with a method and technique for embedding lenticular graphics into plastic objects. For example, imagine a plastic cup, and within that plastic cup, the surface of the cup, was embedded a lenticular or hologram graphic so that it appeared that the graphic was three-dimensional. In this case, the invention was copied, and during the lawsuit, the defendant in this case, the accused infringer in this case, said, well, we have some prior art that invalidates your patent application. And of course, the patent owner, Dynamic Drinkware, said, no, our provisional patent application predates the prior art that you've identified. And so it was up to the court to determine whether there was sufficient detail in the provisional patent application to predate the anticipating prior art. And unfortunately for the patent owner in this case, there was not sufficient detail in the provisional patent application to overcome the prior art that was identified by the defendant. As a result of this, the patent was held to be invalid, and the defendant, the accused infringer, was allowed to continue manufacturing product based on the original patent. One common mistake that companies make when hiring a patent attorney is hiring a patent attorney with the wrong skill set for the inventions that the company has that need to be protected. If your company has invented a new drug containing edited DNA for reversing male baldness in old guys, probably someone with a civil engineering background who's made a career of patenting mechanical tools for road work will not be the right skill set for your drug patent. A somewhat famous case that looks at this in some detail involves an inventor by the name of Herman Minkin. Mr. Minkin was an experienced airplane mechanic, not only with the Navy, but also with several airlines. In the 1960s, Mr. Minkin invented a special tool enabling the mechanic to reach deep inside an airplane engine using a pair of long pliers. Instead of having a single joint like a typical pair of pliers, the pliers had two joints, which enabled the jaws of the pliers to open and close with minimal movement of the handles. Around 1996, Mr. Minkin decided to file a patent application on his tool, and he went to a patent attorney, and the patent attorney and he put together a patent application and filed the application. Now, I want to stop for a second on this story because I'm not quite sure what happened with respect to the facts behind the scene in this case. The patent attorney involved wrote a patent with a relatively narrow set of claims. These claims were rejected by the patent office, and there was some additional back and forth with the patent office in an attempt to find allowable subject matter and allowable claims. It's not clear from the case whether the patent attorney inartfully drafted the patent claims that ultimately issued, or whether the inventor, Mr. Minkin, just ran out of money and gave up. But in any event, the claims that finally issued were extremely narrow. In addition to the elements you would expect in a pair of pliers containing two joints, a handles, and some jaws, there was a limitation in the patent claim that said that the distance from the handle to the first joint was approximately 3 times the distance from the second joint to the end of the jaws. This 3-to-1 ratio was important in the patent claim because it made the patent claim relatively easy to design around. In fact, a customer of Minkin's who was purchasing these pliers from Minkin's tool company ended up designing around the patent and began building competing pliers of their own. These competing pliers in no way infringing the original Minkin patent claims. Now, in this case, Minkin ended up suing his patent attorney, but the case was dismissed on summary judgment on some procedural grounds, so we never really got to understand why the patent claims were written as narrowly as they were. However, the main point of this story is that no matter how good your invention is, if your patent claims are not strong and well written, then the patent itself and the protection it brings could be of little value. It's very important to hire the right attorneys for your technology. The fifth mistake that a lot of companies make with respect to their patent portfolios is failing to consider the value of international patents. Now, international patents are expensive. They're a tax placed on patents, placed on companies by foreign sovereign countries. Nevertheless, there are times when patents can be very important. The value of patents can be very high on certain products, and it's important to consider getting international patents on some inventions. Specifically, if you have significant sales in a specific country, or you're manufacturing or designing in a specific country, or you have a partnership or agreement in a specific country, you may want to consider getting patent protection in that country. One of the particular issues with respect to foreign patent protection is that the dates and the requirements, statutory requirements for filing foreign patent applications are very specific. There's often very little leeway in terms of meeting deadlines. A wonderful characteristic of the U.S. patent system is the amount of grace that's given by the government to inventors in terms of deadlines. For example, typically for responding to most office actions or most responses in the patent office, it's possible to buy a couple of extra months if for some reason you're delayed in responding. If there's an abandonment of a patent application due to failure to respond to an office action, or abandonment of a patent for failure to pay a maintenance fees. In many cases, we can pay an extra fee and petition for revival in the patent office. If we unintentionally forget forget to convert our U.S. provisional patent application at the 12-month period. We're given an extra 2-month grace period, up to 14 months in many cases, to get that provisional patent application converted. However, often not so when filing patent applications in foreign jurisdictions. In many cases, the filing deadlines are absolute and cannot be fixed retroactively. Unfortunately, there are many cases where millions and millions of dollars of value have been lost for failure to timely make applications in foreign jurisdictions. You'll want to carefully calendar these and decide in advance whether you want to file foreign patents or not. It's important to carefully calendar these filing dates. Work with your attorneys to make sure that the dates are docketed. And very often your attorney law firms will work with outside professional docketing agencies who handle foreign filings, such as CPA Global and others. There was a cautionary case about 10 years ago in Atlanta, Georgia, where a neurosurgeon had invented a medical device and had intended to file it in various countries overseas. The docketing company that had been hired to docket and to calendar the filing dates in these foreign countries had made an error, an entry error, and as a result, the filing dates got missed and a complete loss of patent rights in those foreign countries resulted. There was an ensuing lawsuit by the neurosurgeon against the docketing company for some $93 million. In many cases, these foreign patent rights can be very valuable. Okay, that's all I have today on 5 mistakes that companies make that could cost them millions. Thank you so much for watching my video. If you have any questions, put them in the comments section below. I'd love to read about them. If you need help with your patent portfolio or your company's patent strategy, I'd love to hear from you as well. You can reach me at the email address attached. Thanks again for visiting my channel, for watching this video. I'll see you on the next one.